Hi, we've just gone over the idea of assignments versus subleasing, and I want to put that in a small recap summary of the topics. First of all, remember when we're talking about assignments and versus subleasing, what we're really talking about are transfer of leasehold interest, whether that be a transfer of the landlord's interest side or a transfer of the tenant's side. Essentially, an assignment or a sublease is just a transfer of those rights. Now, when we're looking to the idea of an assignment, the most important aspect of that or characteristic of an assignment is that you're looking at a transfer of the tenant's existing lease to a third party. I mean, the entire remaining balance of that lease is going to be transferred, and that's essentially the majority viewpoint, or the majority test is whether or not the balance of the lease has been transferred. If even one day is retained, then the majority viewpoint is that you don't have an assignment, but you in fact have a sublease. The minority viewpoint is that they look to the intent of the parties and not whether or not the balance of the lease has a factor in whether it's assignment or a sublease. Now, there are some viewpoints that a power of termination or a right of re-entry in and of itself does not create a sublease situation, meaning if I have assigned this lease and I have no revision rights no reverter rights back to me as far as the term of the lease, but I do have a power of termination. For example, the example we used in the seminar is the apple orchards, and X is now in charge of caring for the apple orchards, but doesn't take care of those apple orchards, then the assignor has the ability to come in and terminate that lease. That still can be characterized as an assignment in some jurisdictions or in most jurisdictions. However, the majority viewpoint is, and the focus is in the balance of the lease being assigned or being transferred. Now, when you're looking to an assignment, you have basically two ideas that you're looking to is privity of contract and privity of estate, and those concepts are analyzed in terms of a triangle or an equal sides triangle, where you have the landlord, which is usually identified as A, the tenant, which is usually identified as B, being one side, and then the next side of a triangle, and then the third side being C, the assignee of this triangle, and they all have certain equal rights that transition back and forth. And that's viewing it from a triangle point of view is a good way of analyzing it or thinking about it in terms of an assignment. If we're looking at a privity of contract, the privity of contract arises between B and the assignor and C, the assignee, when the assignment occurs. So you have a privity of contract situation there. You will have a privity of estate now between A and C at the same time, but not a privity of contract, because there's no direct contract between A and C on the contract terms. You will have that under the estate terms because B no longer has an interest in the property. That interest has been transferred to A or to C, and C now stands in B's shoes for that purposes. Now, it's also important to understand that unless specifically released, B still has a contractual obligation to the rent and to the debts. So if C doesn't follow through, A could go after B for the contract rent claims and go after C for the estate claims, for the rent covenant claims. All right. When we're looking to a sublease, essentially what we're looking at is the idea of a creation of a whole new landlord-tenant relationship. So, for example, we have A and B's landlord-tenant relationship, and between A and B, there's still this privity of estate and there's this privity of contract. And then you have B and C, who's created another landlord-tenant relationship where there's a privity of contract and a privity of estate between B and C. Now the real question becomes, A and C do not have the ability to directly sue or directly countersue each other, as B is the middleman in this area. And it's important to understand that in a sublease situation, B retains that interest in the property. Okay. All right. I have attached or uploaded a mind map outlining these elements in your doc sharing provisions, and I hope this helps to clarify some of the differences between assignments and sublease. Thanks. Bye.